In Wisconsin, a man asked to see the algorithm that sentenced him. The court said no. The Wisconsin Supreme Court said no. The United States Supreme Court declined to hear it. In Kansas, a different man asked the same question. A court agreed with him. His sentence was vacated. The difference between those two outcomes is not the algorithm. It is not the question. It is not even the law. The difference is the state. There is still no federal rule that answers the question Eric Loomis asked in 2013. There is still no constitutional precedent that protects every defendant in every courtroom in the United States. By the end of this video, you'll understand exactly what legal protection you have, or don't, based on where you are. This is the algorithmic verdict. In the last investigation, we followed Eric Loomis, sentenced in Wisconsin using a compass algorithm he was never allowed to examine. The Wisconsin Supreme Court upheld the practice. The U.S. Supreme Court walked away. What we didn't show you is what happened next. Because after Loomis, the legal question didn't disappear. It fractured. Different courts, in different states, with different defendants asking different versions of the same question, got different answers. The law on algorithmic sentencing in America is not settled. It is a patchwork, and the pattern of that patchwork says something important about who is protected and who is not. And in February 2025, something happened in Europe that made the American patchwork even harder to defend. But before Europe, there is a man in Kansas who asked the same question as Loomis. And this time, a court listened. A defendant in Kansas, we'll call him Walls, as he appears in the legal record, was sentenced to a highly supervised form of probation. The conditions of that probation were shaped in part by an LSIR risk assessment, the level of service inventory, revised. The LSIR, like Compass, is a proprietary tool. It generates a score based on factors including criminal history, education, employment, family circumstances, and peer associations. The defendant received a score, placing him in a category that triggered stricter supervision conditions. Walls asked to see his complete LSIR assessment, the full calculation, not just the output score. The court refused. He appealed. The Kansas Court of Appeals agreed with him. The court's reasoning, denying Walls access to his complete assessment, made it impossible for him to challenge the accuracy of the information used in determining the conditions of his probation. The original sentence was vacated. The case was sent back for resentencing. 2 men, 2 risk assessment tools, 2 courts, 2 outcomes. Loomis in Wisconsin, appeal denied. Constitution does not require access to the algorithm's methodology. Walls in Kansas, appeal granted. Due process requires access to the complete assessment used against you. These 2 rulings cannot both be the definitive answer. One of them is wrong, or both of them are right in their own jurisdictions. Or, and this is the real situation, there is no federal answer, and the right to challenge an algorithm that helps sentence you depends on geography. The U.S. Department of Justice has acknowledged that a sentencing court's use of actuarial risk assessments raises novel constitutional questions. Novel means unresolved. Novel, in 2022, means that 9 years after Loomis was sentenced, the federal government had not answered the question he asked. If you or someone you know has been through the sentencing process and received a risk score, or been told you couldn't see it, say so in the comments. Which state? What tool? These patterns matter to researchers and advocates. While there is no federal answer, some states have moved. In March 2019, Idaho became the first U.S. state to require transparency in pre-trial risk assessment tools. The Idaho law prevents companies from using trade secret law to block defendants from accessing their assessment. It requires public availability of all documents, data, and validation information used to build the tool. It empowers defendants to review every calculation that went into their score. Colorado has required bias audits of risk tools used in criminal sentencing. New Jersey has placed restrictions on how algorithmic tools can be used in bail decisions. But these are individual state laws. They protect people in those states. If you are sentenced in a state that has passed no such law, you are in the same position as Loomis in 2013. In February 2025, the European Union's AI Act reached its first major enforcement milestone. Article 5 of the AI Act lists what the EU considers unacceptable risk, practices so dangerous to fundamental rights that they are simply prohibited. Article 5(1)(d) prohibits AI systems that assess or predict the risk of a person committing a crime, based solely on profiling or personality traits and characteristics. The logic behind tools like Compass, scoring recidivism risk based on demographic and personal factors without requiring objective evidence of specific criminal conduct, falls close to the kind of practice this prohibition targets. Whether Compass itself would be found in violation depends on enforcement and interpretation, but the prohibition was written with exactly this type of tool in mind. What the Wisconsin Supreme Court called constitutional in 2016, the European Union called unacceptable in 2025. There is a second layer to the legal problem that goes beyond sentencing. Compass, LSIR, and similar tools are proprietary. Their source code, training data, and methodology are protected as trade secrets. That means, even if a court rules that a defendant has the right to challenge the score, the company that built the algorithm does not have to explain how it works. The defendant can see the questions they answered. They can see the output number. But the model that converted their answers into that number, the weights, the training data, the validation methodology, is invisible. As the UCLA Law Review put it, no one truly knows how Compass calculates its risk score. Not the prosecutors who use it, not the defendants who are sentenced by it, and, as a concurring justice in Loomis noted, the court repeatedly questioned both sides about how Compass works. Few answers were available. A judge sentenced Eric Loomis using a tool that the judge did not fully understand. A tool whose creators were not required to explain it to anyone. This is Shadow Structures, where we investigate the systems that shape your life without you ever seeing them. This is the penultimate episode of this series. Next, the finale. Every system, every mechanism, one conclusion. I want to be direct with you. Your protection from algorithmic sentencing depends on the state where you are convicted. In Idaho, you have the right to see the full risk assessment used against you. In Kansas, a court has ruled that denying you that access violates due process. In Wisconsin, the opposite ruling stands. In most other states, the question has not been definitively answered. One state over, the answer could be different. Now the full scale. Risk assessment tools are used in sentencing, bail, and parole decisions across nearly all 50 states. The National Center for State Courts documents their use in at least 46 states. In most of those states, there is no law requiring the algorithm to be disclosed to defendants. In most of those states, trade secret law means the methodology cannot be independently examined. There is one federal court decision that touches this. In 2017, the U.S. Department of Justice acknowledged in a brief that algorithmic risk assessments raise novel constitutional questions, meaning questions the federal courts have not yet resolved. Novel in 2017, 8 years later, in 2025. Those questions are still novel. Every year that passes without a federal answer is another year that millions of bail, sentencing, and parole decisions are made using tools whose methodology cannot be examined, challenged, or verified. The Loomis Advisement, the Wisconsin Supreme Court's series of required advisements to judges, acknowledges that the tool may disproportionately classify minority defendants as higher risk. It acknowledges that the methodology cannot be disclosed. It acknowledges that there is no cross-validation study for a Wisconsin population. It acknowledges all of that, and still says, proceed. Loomis asked to see the algorithm. The court said no. Walls asked the same question. A court said yes. That difference between no and yes is the difference between a man whose sentence stands and a man whose sentence was vacated. What does it mean for you? Your toolkit. And it depends on where you are. 1. Know which tool was used. If you or someone you know is being sentenced, ask directly, was a risk assessment tool used in preparing the pre-sentence investigation report? Which tool? What score? You have the right to see the PSI, and the PSI must contain the score. The score is the starting point for any challenge. 2. In Idaho, you have the strongest protection. Under Idaho Code Section 18-8005A, the tool's full methodology, training data, and validation documentation must be publicly available. Trade secret law cannot be used to block access. If you are in Idaho and these materials have not been provided, that is a legal violation. 3. In other states, the Walls versus Kansas precedent offers a possible argument that denying access to the complete assessment, not just the score, violates due process. This argument is not settled federal law, but it has succeeded at the appeals level. An attorney familiar with algorithmic sentencing challenges can assess whether this argument applies in your jurisdiction. 4. Challenge the validation. The Loomis Court required PSI reports to note that Compass has not been cross-validated for a Wisconsin population. The same is true of most risk tools used in states that have not conducted their own validation studies. An attorney can argue that a tool applied to a population for which it was not validated cannot be considered reliable evidence. 5. If you are in Europe, or the tool's output was used in a country subject to the EU AI Act, Article 5(1)(d) prohibits algorithmic crime prediction based solely on profiling. A tool that violates this provision was operating illegally. File a complaint with the National Market Surveillance Authority. 6. Support federal legislation. The core problem is the absence of a federal standard. Organizations like the ACLU, the Electronic Frontier Foundation, and the Brennan Center for Justice are actively pushing for federal legislation requiring transparency, independent validation, and defendant access to risk assessment methodology. These efforts need public pressure. Eric Loomis lost. Walls won in Kansas. The difference between those two outcomes should not be geography. We began this series with a man who had a credit score he couldn't fully explain. We end the penultimate episode with a man who had a criminal risk score he was not allowed to question. Both scores were produced by algorithms. Neither score was fully transparent to the person it affected. Both scores shaped the material conditions of a life. The difference is the stakes. A credit score shapes your access to a mortgage. A criminal risk score shapes whether you go to prison. And the legal protection, in both cases, follows the same pattern: incomplete, fragmented, jurisdiction-dependent, and lagging decades behind the technology it is supposed to govern. Shadow Structures investigates the systems that shape your life without you ever seeing them. This was the algorithmic verdict. We have now investigated 11 systems: credit scores, dynamic pricing, dating apps, ATS filters, video interview AI, banking algorithms, data brokers, surveillance software, health algorithms, pre-crime scores, algorithmic sentencing. 11 systems, one pattern. In the final episode of Shadow Structures, what does it mean when all of these systems operate at the same time, on the same person, without that person knowing? And there is one more system we have not yet investigated. The system that decides which of these stories you ever see. The feed algorithm. The one that decided whether you found this series, or whether it was invisible to you. If this series has changed how you understand the systems around you, share this episode. Not because it benefits the channel, because the algorithm deciding whether someone finds this series is itself a system we investigate in the finale. Eric Loomis asked a question a court couldn't answer. You now know why. The next time someone you care about is in a courtroom, the question is still there. It still doesn't have a federal answer. The next time someone you care about stands in a courtroom, the presence or absence of a protection like walls had in Kansas will depend entirely on the state line. One state over, the answer might be different. That is not justice. That is geography.
Yeah.